Welcome, everyone. I'm going to speak about Polish cases in the Court of Justice of the European Union. Okay, I come from Poland. I come from Kraków, from the southern part of Poland, and I work at the University of Economics. I am a political scientist and a lawyer.
Ask them if they can hear you.
Sorry?
Ask them if they can hear you.
Okay, can you hear me? Can you hear me?
Yes, they can hear.
Okay, that's good. I wanted to say a couple of words about the so-called Copenhagen Dilemma. As we know, the rule of law is an important item in the accession negotiations. And the Copenhagen European Council from December 1993 formulated the so-called Copenhagen criteria that countries applying for the membership in the European Union must fulfill. And one of these criteria is institutional stability. And the fulfillment of this criteria is meticulously assessed prior to the country's accession to the European Union. But the issue is that after accession, there is no mechanism for scrutinizing the country's compliance with this criteria. There is an exception now, because with the accession of Bulgaria and Romania, we have an instrument that we can scrutinize the compliance of countries with Copenhagen criteria, but it is not the case for the countries which access the European Union in 2004. I mean, Copenhagen criteria, it was 1993, but it was especially focused on the countries that acceded the European Union in 2004. Most of them countries coming from so-called social, not communist, but post-Soviet bloc. And that's why independence of judiciary and judges is an important item in the accession negotiations. Hence, the Commission criticizes an excessive political influence exerted on the judiciary, stresses the need for political neutrality, raises objections as to the transfer of judges to other courts without their consent. It is not only transfer of judges, as well prosecutors, they are as well transferred to other places, emphasizes the role of transparent disciplinary proceedings against judges. These cases are now in the Court of Justice, pending in the Court of Justice of the European Union. It draws attention to the composition of disciplinary bodies. It is a highlighted issue, disciplinary bodies, especially in the Supreme Court. It is the disciplinary chamber and the composition of this chamber. And in the Supreme Court, we have as well the Council for Judiciary, and it is another issue, the composition of this body, which used to be composed by the peers, it means by judges, and now it is composed by the legislative branch. It is by the lower chamber of Polish Parliament. It is by Sejm. And criticizes competences of the ministers of justice as to the control over the composition and functioning. Sorry, but I cannot.
No, we need to.
Yes, that's okay. Over the composition and functioning of judicial councils, while underlining that they should be composed mainly of judges and be independent of the ministers of justice. It is an issue. Minister of Justice is at the same time the prosecutor of the country, and he is at the same time the politician, and it can be an issue. According to the Court of Justice, these elements taken individually, they do not cause such a problem. But when they are taken together, when they are composed together, then there is a problem as far as judiciary in Poland is, goes. In the Commission's communication on the rule of law, we can read that compliance with the rule of law is not only a prerequisite for the protection of all fundamental values listed in Article 2, it is also a prerequisite for upholding all rights and obligations deriving from the treaties. And the rule of law means, according to the former Commissioner of the European Commission, means that law and justice are upheld by an independent judiciary. I mean, the issue is the rule of law, but an element that is crucial that constitutes the main part of rule of law is independent judiciary. Accepting and respecting a final judgment is what it means to be part of a union based on the rule of law. Our member states gave final jurisdiction to the European Court of Justice. The judgments of the court have to be respected by all. To undermine them or to undermine the independence of national courts is to strip citizens of their fundamental rights. The rule of law is not optional in the European Union. It is a must. Our union is not a state, but it must be a community of law. Then why rule of law is so important? The European Union is not a state, it is an international organization, but it is an organization of a special kind. And because it is not a state, it does not have a coercive power. That's why only via law, via legal instruments, via legal procedures, European institutions, European Union can hold member states into account. And it is the only instrument. That's why rule of law is so important. Another issue is that national lawyers are at the same time European lawyers. It means that they interpret and apply not only national law, but as well European law. And I see problem maybe is that we tend to see the European Union as a classical international organization, but it is not, because in classical context, national lawyers apply national law and international lawyers international law. How the international law then is applied into national context, it is up to national institutions, up to national legislative branch. But okay, it depends if it is monist or dualist system. But in the European Union, as we know, the law is applied or can be or may be applied directly. It does not have to, but it applies and it can have direct effect. Okay, then we have as well the statement from the European Parliament concerning the Copenhagen Dilemma. And it was said that the European Parliament reiterates the urgent need to tackle the so-called Copenhagen Dilemma, whereby the European Union remains very strict with regard to compliance with the common values and standards on the part of candidate countries, but lacks effective monitoring and sanctioning tools once they have joined the European Union. It is just reiteration what was said before, that countries, that European institutions, they have instruments to hold member states into account, or to scrutinize the institutions of the member states. How do they stick to, the values that are present in the European Union? But after accession, it can be an issue. It can be a problem. And as far as the mechanism of protection of the rule of law go, we have political, judicial, and economic. I will say only a couple of words on political and judicial, and then Polish cases in the Court of Justice of the European Union, and economic, then it is not an issue here, then I will leave it. We have procedure under Article 7 Treaty on the European Union. And this procedure tries to reconcile sanctions with respect for sovereignty. And why is it so? Because it is because who decides under Article 7? It is Council of the European Union. It means member states. In Article 7(1) and in Article 7(2) it is European Council, and it is unanimity. It is we have here an intergovernmental element in this procedure. That's why it is seen by some as, or by most of politicians, as political instrument, but European institutions, they want to see it more as a legal instrument, and this especially the European Commission wants to operationalize it, and did it in a way of this communication. The framework on the rule of law from 2014. I will just say a few words later on. That's why the procedure under Article 7 is complex and rigid, difficult to initiate, requires political will on the part of the member states. Then, as I said, it is characterized by intergovernmental element, and it is multi-staged. We have this first stage, a clear risk of a serious breach by a member state of the values referred to in Article 2, and the second stage, the existence of a serious and persistent breach by a member state of the values referred to in Article 2. I mean, it is important, here we have two stages, but it is important which stage is it, because if it is the second stage, if it is declared that there is an existence of a serious and persistent breach, it is a systematic breach of the rule of law, then it has consequences. As far as European arrest warrant is concerned. There are some cases in the European Court of Justice in the way of preliminary rulings that concern Polish citizens under European arrest warrant. But I will say a few words later on. The Commission initiated the procedure against Poland by submitting on December the 20th, 2017, a recent request pursuant to Article 7.1 regarding a decision of the Council to determine a clear risk of a serious breach by Poland of the rule of law. The Commission's proposal was supported by the European Parliament in a resolution which was issued in March 2018. I wanted to stress that Article 7.1 is independent of Article 7.2. It means that European Commission could initiate as well the procedure under Article 7.2. But even under Article 7.1, it is a stage of dialogue, of deliberation in the Council of the European Union. This article is not applied automatically, which combined with the need to seek political consensus among member states make it poorly suited for an effective and rapid response to systemic threat to the rule of law. A procedure was in the Commission's communication 2014. It was in March 2014. The Commission published a new European Union framework to strengthen the rule of law to address systemic threats to the rule of law. There must be under threat, and it is important because the Commission, the issue is here that we have rule of law, but the rule of law is not European rule of law. We didn't have, or now we do have, but we didn't have definition. What is European EU rule of law? When we speak about European principles, it's very often we resort to national constitutional traditions. We take them from the constitutional settings of the member states, and in fact, in constitutional traditions of the member states, in the constitutional systems of the member states, there is such a thing as rule of law. But what is European rule of law? How to operationalize it? And in this communication of the European Commission, Commission said that there must be under threat political, institutional, and legal order of a member state as such. Its constitutional structure, separation of powers, the independence or impartiality of the judiciary, or its systems of judicial review, including constitutional justice, as a result of the adoption of new measures or of widespread practices of public authorities and the lack of domestic redress. The framework will be activated when national rule of law safeguards do not seem capable of effectively addressing those threats. And then the framework will be activated in situations where the authorities of a member state are taking measures or are tolerating situations which are likely to systematically and adversely affect the integrity, stability, or the proper functioning of the institutions and the safeguard mechanisms established at national level to secure the rule of law. And the process is composed, this process, which I have to say, was not welcomed by the Council of the European Union, because Council said that as far as Article 7 is concerned, it is up to us, and it is not for the Commission to initiate, I would say, pre-Article 7 stages. But the process is composed of 3 stages: assessment, recommendation, and follow-up to recommendation or recommendations. And the procedure was applied to Poland. It was in January 2016. It was first stage, dialogue, which enabled the state to withdraw from the violations. Then we had 3 recommendations. And then in 2017, in December, stage 3rd, recent proposal in accordance with Article 7.1 regarding the rule of law in Poland. Okay, and this procedure, we can say, is pending. It is now up to the Council of the European Union to decide. Then, as far as the judicial mechanisms are concerned, we have direct complaint, what just Stephanie mentioned, direct complaint, an instrument provided for in Article 258, and then non-compliant proceedings, preliminary questions from national courts based on Article 267. And here was an issue as well, because till the judgment, in the Association Syndicale 2018, it was not. I mean, these articles, these procedures, they were not used as far as rule of law was concerned. Then, as I say, till this judgment in 2018, it was not clear whether Article 258 could be used to protect the rule of law in relation to the independence of judiciary and judges. The question was whether Article 19, which requires from the member states the establishment of remedies to ensure effective judicial protection in areas covered by European Union law. This is an important issue. It was important for Advocate Generals and European Court of Justice. They are covered by European Union law in conjunction with Article 2, European values, may serve as an independent legal basis for a compliant in a situation where no other norms of European Union substantive law is alleged to be breached. Because under Article 258, there must be a breach of a substantive law. Of a substantive law, either primary or secondary. And here, under Article 19, and Treaty on the European Union, and under Article 2, we do not have as such. It does not. Yes, it seems not to be the case, but after judgment in 2018, it is possible. And now, under Article 258, this article can be effectively used to protect the independence of national courts. It can be used in parallel to and independently of Article 7. It is another issue that is important, that this procedure can be paralleled. It means it is procedure under this political procedure under Article 7 and this judicial under Article 258. This article provides for a three-step procedure. If the Commission believes that the state has failed to fulfill an obligation, it carries out an informal investigation. In the case of Poland, the Commission initiated infringement proceedings, it was July 2018, by sending a letter of formal notice concerning the law on the Supreme Court. It was a very famous case on the Supreme Court. I will talk later about it. As Poland's reply did not convince the Commission, it proceeded to the second stage in the form of a formal investigation by sending to Poland on August 2nd, 2018, a recent opinion with regard to the law on the Supreme Court. And since Poland's response did not satisfy the Commission, on September 24th, 2018, it decided to sue Poland before the Court of Justice of the European Union. And then we have the procedure under Article 267. Questions may be raised by any national court where, in connection with a pending dispute, a question arises concerning the interpretation or validity of acts of European Union institutions, bodies, offices, or agencies. Until 2018, a preliminary ruling instrument was not used as a means to protect the rule of law, what was mentioned before, regarding the independence of courts and judges. The reason was that the question referred must concern an interpretation of European Union law. Hence, the national court, when submitting a question, must provide a specific substantive material rule of European Union law. And it was an issue till 2018. And since the organization of judiciary does not fall within the catalogue of competences transferred to the European Union, hence, it cannot be subject of a reference for a preliminary ruling. This approach has changed as a result of the judgment in the case Association Syndicale. Very often it is said that this judgment is of a constitutional importance. Even it is said that it revolutionized in a way, I mean, the judiciary system in the European Union. In which European Court of Justice decided to base its decision on Article 19.1. By adopting as an independent legal basis Article 19, the Court significantly extended the scope of legal protection compared to the possibilities resulting from Article 51 under the Charter of the European Union. I mean, the issue is here that, okay, we have Charter and Article 47 here is at stake, but it is the same. It is the same issue. There must be a breach of a substantive provision of a substantive EU EU law. It must. The EU Charter operates within the EU law, and Article 19 does not fall under the provisions of the Charter of the European Union. That's why Charter could not come here as a legal basis for cases involving rule of law. Okay, Charter was used. Article 47 was used when there was the legal base was Article 19, of the Treaty of the European Union, Article 2, Treaty of the European Union, and Directive, Equal Treatment Directive. Then we had here this breach of the substantive EU law. Then that's why it was important that the court case could be based solely on Article 19.1 of the Treaty on the European Union. Article 19 becomes an independent legal basis for assessing allegations related to possible shortcomings in ensuring effective judicial protection. Also regarding legal regulations not related to the application of European Union law, but falling into the areas covered by EU law. Legal regulations not related to the application. It means that as far as Article 19 is concerned, EU law does not have to be applied. EU law, it is enough that it falls into the areas covered by European Union law. And as I said, the intellectual construction adopted by the Court of Justice revolutionizes the way of protecting the rule of law in the European Union. In addition to the political centralized model, what just Stefani referred to, under Article 7, a decentralized judicial protection is possible, which would be problematic under Article 51 of the Charter. And here, question whether under preliminary reference it is possible to examine questions relating to the administration of justice, in particular the independence of courts and judges. Yes, answer is positive. As the independence of national courts and judges is essential for the proper functioning of judicial cooperation in the form of request for a preliminary ruling under Article 267. Then here we have another element, judicial cooperation. It is important that all courts are independent, judiciary is independent because of judicial cooperation between courts, between national and European courts. According to the Court of Justice of the European Union, those guarantees of independence and impartiality require rules, particularly as regards the composition of the body and the appointment, lengths of service, and grounds for abstention, rejection and dismissal of the members, in order to dispel any reasonable doubt in the minds of individuals as the imperviousness of that body to external factors and its neutrality with respect to the interests before it. In order to consider the condition regarding the independence of the body concerned as met, the case law requires inter alia that the dismissals of its members should be determined by express legislative provisions. Then, member states have, as I said, organizational and procedural autonomy. It is competence that falls under the member states' competence in shaping their judiciary, which the European Union cannot enter because it is the competence of the member states. But the limits of this autonomy is the independence of judges and judiciary. The breach of these values directly harms European judges who are functionally national judges and vice versa. It also undermines the coherence and application of European Union law. In such situations, the Court of Justice of the European Union must be empowered to review and assess whether the standard of Article 19 and Article 47 of the Charter allows restrictions on the independence of the judiciary. And there is another judicial instrument, and these are interim measures. Interim measures were not an issue before the Polish cases. The first case that came here was very famous as well, Białowieża case. It concerned Polish, very, very old forest, the only in existence in Europe, in the European Union. And it was under this interim measure, it was possible for the Court of Justice to apply it was not application because Poland changed its behavior, its law, but to apply financial penalties. Before it was not possible because financial penalties may be applied under Article 260. There is a special procedure, but here for the first time under interim measures, the court applied financial penalties. It was under Article 279 because we have Article 278, but in 279 it is written the Court of Justice of the European Union may, in any case before it prescribe any necessary interim measure, because it is this any, and it could be financial penalties. They were not applied in the very end, but they were just declared by the Court of Justice that if Poland does not stick to the recommendations of the Commission, then it does not change. It concerns logging of an ancient forest, I would say, and it was finally changed, and the measure wasn't applied. Financial penalties. Poland didn't have to pay the penalties. And here the Court of Justice distinguishes between the suspension of application of the contested act and other interim measures. Article 278 refers to complaint proceedings, which precludes its application in the case of preliminary rulings. In turn, Article 279 does not contain such a limitation, but a systemic interpretation suggests that it also applies here. Hence, interim measures may be applied by the Court of Justice only in the course of examining complaints concerning the procedure, the protection of the rule of law submitted by the Commission pursuant to Article 258. It means that interim measures, they cannot be applied under the procedure of Article 267, it means preliminary ruling, but under this pursuant to Article under the procedure pursuant to Article 258. The decision of the President of the Court on the application of interim measures is not subject to appeal and is valid until the date of the judgment in the given case, but depending on the change in circumstances, it may be changed or revoked at any time at the request of a party. The implementation of the interim measure should be automatic, it is automatic, and do not require any national implementing measures. The decision to apply them is binding on the state, and the state is obliged to implement it. And now I'm coming to the Polish cases. It started in 2015 and it started with the Polish Constitutional Court. Reforms of the judiciary in Poland has been a major source of controversy, both domestically and at the European Union level, and they affected Constitutional Tribunal or Constitutional Court, but we say in our language this tribunal, the Supreme Court, ordinary courts and prosecution service, and National Council for the Judiciary, here as well the disciplinary chamber of the Supreme Court. And they have increased the influence of the executive and legislative powers, or executive and legislative branch over the judiciary, and thus weakened judicial independence. This led the Commission to launch in 2017 the procedure under Article 7, what I just referred to, which is still under consideration by the Council. But in 2018, 19, 2020, and in 2021, the Commission launched infringement procedures to safeguard judicial independence, and the Court of Justice has granted interim measures to suspend the powers of the Supreme Court's disciplinary chamber with regard to disciplinary cases concerning judges. But further concerns, the elements that are an issue here, it is Minister of Justice who is also the Prosecutor General. I just referred to it at the very beginning. He is as well politician. It means that he is in the capacity of being Minister of Justice, being Prosecutor General, and being a politician. And the fact that the reforms were adopted under expedited procedure and thus with limited consultations. And we have here the case under Article. I talked about Article 258, then 267, and then interim measures because now I am referring to them. Under Article 258, and it was what Stephanie as well referred to, European Commission versus Republic of Poland. As a result of a complaint from the Commission, the court ruled that the provisions of an act on the Supreme Court of 2017, reducing the retirement age of judges of the Supreme Court and the Supreme Administrative Court from 70 to 65, are contrary to European Union law. This act applied inter alia to the President of the Supreme Court, whose a 6-year term of the office is regulated in the Constitution. And it is an issue as well, because the President of the Supreme Court should be president of the court, of the Supreme Court, and the term of office is 6 years, and it is provided for in the Constitution. It is not only law, ordinary law, but it is in the Constitution, and it was as well an issue here. And the President of the Criminal and Labour Chamber. The controversial provisions were changed before the Court of Justice of the European Union ruled on the issue. It means that we didn't have to pay penalties because of interim measures and penalties which were declared. And not questioning the national competence in the area of the organization system in the judiciary, the Court of Justice stated that by lowering the retirement age of the Supreme Court judges before the end of their term of office and granting the President of the Republic of Poland the discretionary right to extend the active service of some judges of the Supreme Court, Poland violated the obligation under Article 19. In fact, here were two issues. One, it was, I just talk a little more. One was, the curtailment, the reduction of the retirement age, and another one was that the President of the Republic could prolong twice, 3 years and 3 years, together 6 years, could prolong the mandate of a judge, just being active, being in service, and he could do it on the request of the National Council for Judiciary. But the issue is that National Council for Judiciary is now, after the reform, appointed by the lower chamber of the Parliament. That's why the question is whether the National Council of the Judiciary is independent. It means whether it is not. Whether it does not fall under the pressure of external pressure as it was mentioned in the previous lecture. Article 19 says member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by European Union law, and Article 47 of the Charter is under the heading right to an effective remedy and to a fair trial. We will need to these two articles. Facts and legal basis. On October 2nd, 2018, the Commission launched infringement proceedings against Poland, alleging a failure to fulfill its obligations under Article 19 and Article 47. We do not have here substantial law. We do not have any other provision. We have on Article 7, it is Charter on the European Union, and Article 19, how to operationalize it. Is there any substantive law, that is breached? The contested provisions were Article 37 and 111 of the new law on the Supreme Court. These two provisions, read in conjunction, lowered the mandatory retirement age for Supreme Court judges, including those already sitting in the Supreme Court, from 70 to 65, and granted the President of the Republic a discretionary power to extend the judge's mandate beyond the newly fixed retirement age. The Commission also requested the Court of Justice an interim measure in order to suspend the applicability of the contested provisions. The measure was granted in October by the Vice President of the Court of Justice, and it was later confirmed by the Grand Chamber. It is another issue. The Polish cases, even concerning the issue whether the procedure should be expedited or whether to declare interim measures, they were decided in Grand Chamber, and because of seriousness of the issue. And as a consequence, the Polish government decided to repeal the law and reinstate in office 27 judges concerned by the new law. And according to the Advocate General, Article 19 constitutes an autonomous standard for ensuring that national measures meet the requirements of effective judicial protection, including judicial independence. It means now it is possible, to base a case only on Article 19. And we do not need another provision either of primary law or of secondary law that is breached. It is enough that here Article 19 is at stake. And against which evaluating the respect of the requirement of effective judicial protection and judicial independence. Having established that the new law on the Supreme Court was not implementing European Union law within the meaning of Article 51, because it was not an implementation, it is a requirement of the Charter that the European law must be implemented. It was not the case. The Advocate General assessed the merit of the action solely with regard to Article 19. The Advocate General reached the conclusion that both the lowering of the mandatory retirement age for judges already in charge when the law entered into force and the discretionary power of the President of the Republic to extend their mandate violated the European Union law. And thus, according to the Advocate General, the contested measure violated the principle of irremovability, what Stephanie referred to, irremovability of judges, whose observance is necessary to meet the requirements of effective judicial protection under the second subparagraph of Article 19.1. As far as the court is concerned, the answer from the court, as for the procedural aspects, the court did not consider it necessary to proceed with an assessment of the Charter. I mean, it was an issue because for the Advocate General, he said that the charter does not come into play here because there is not a breach of the case that is at stake. There is not an application of European Union law. There is not a substantive law involved in this case. But that's why, and it is a requirement of Article 51 of the Charter of the European Union. But for the court said, I will not deal with it because Article 47 of the Charter, it is as well general principles of law. I mean, some principles which are enshrined, provisions and principles which are enshrined in the Charter are treated at the same time as general principles of law, and then that's why they are applied irrespective of this, whether they are in the Charter or not. They are valid for us, general principles of law. We apply them nevertheless. Did not consider whether considered necessary to proceed with an assessment of the Charter's applicability under its Article 51. The court recalled that the principle of effective judicial protection was a general principle of European Union law, which Article 47 only reaffirmed. Then it was independently of the Charter. It is good that it is stated in the Charter, that it is reaffirmed in the Charter, but it is valid for us, it is binding because of being a general principle of European Union law. The principle of the effective judicial protection of individuals' rights, this according to the courts, under European Union law referred to in the second subparagraph of Article 19, is a general principle of European Union law stemming from the constitutional traditions common to the member states, which has been enshrined in Article 6 and 13 of the European Convention of the Protection of Human Rights, and which is now reaffirmed in Article 47 of the Charter. The court reaffirmed that the only element to be evaluated when assessing the applicability of Article 19 is whether the court or tribunal concerned may be called upon to rule on questions concerning the application and interpretation of European Union law. And the key word here is may. It is common ground, I mean, according to the court, it is common ground that the Sąd Najwyższy, the Supreme Court, may be called upon, maybe, I mean, hypothetical, potential, in future possibility, may be called upon to rule on questions concerning the application or interpretation of European Union law. And that as a court or tribunal, within the meaning of European Union law, it comes within the Polish judicial system in the fields covered by European Union law, within the meaning of the second subparagraph of Article 19, so that the court must meet the requirements of effective judicial protection. It was I mean, it is in fact in a way revolutionary, I would say, because it was I mean, in the literature. I'm just reading on the Code of Justice. It was said that, I mean, the judicial activism is just the past, but it is not the case. I mean, from 2018, we have renewed judicial activism. As I said, there were two issues. One, the curtailment of the retirement age, and another one is the procedure which leads to the prolongation of the judge's mandate. Speaking about the retirement age, I was just thinking, because we say retirement age, but in fact, I mean, the issue is whether judges and prosecutors, they do retire. The issue is not necessarily. It is in a way a state of rest. They are not active. Okay, we say they retired, but I mean, the point is that they do not contribute to the pension schemes, because for judges and prosecutors, there is not such an issue as retirement. I know, because my brother is prosecutor, and there's always this conversation. I have to pay for the pension scheme, and him not. He does not. He's a prosecutor. He will be a prosecutor. Not active. He will retire, and okay, it can be an issue, but okay, I find it discriminatory that I do pay. I contribute to the scheme, and him not, but it is a case. Okay, there is this retirement age which was set at 70, and now under the new law it is 65. The first issue, and the second, the procedure leading to the prolongation of the mandate of on the mandate of judges and prosecutors. On the first point, the Court of Justice clarified that the principle of irremovability of judges is not absolute, and that exceptions are allowed provided that are based on legitimate and compelling grounds and subject to principle of proportionality. The principle of irremovability, according to the Court of Justice, requires, in particular, that judges may remain in post provided that they have not reached the obligatory retirement age or until the expiry of their mandate, where that mandate is for a fixed term. While it is not wholly absolute, there can be an exceptions to that principle unless they are warranted by legitimate and compelling grounds subject to the principle of proportionality. I'm speaking about retirement. The issue is that as far as the president of the Supreme Court is concerned, it was in contradiction what is written in the Constitution. The court added that restrictions should not raise reasonable doubt in the minds of individuals as to the imperviousness of the court concerned to external factors and its neutrality with respect to the interests before it. And on the second point, the court assessed whether the procedure for extending the judge's mandate provided sufficient guarantees to protect them from political influence and dispel doubts concerning their independence and impartiality, taking into account the fact that the National Council of Judiciary opinions on the extensions requests were not reasoned, and that the body itself couldn't be considered independent, what I said, because being elected by the legislative branch, the court, and even judges were not representative. The court concluded that the unfettered discretion accorded to the President of the Republic was capable to give rise to reasonable doubts inter alia in the minds of individuals as to the imperviousness of the judges concerned to external factors. The discretion held by the President of the Republic for the purpose of authorizing twice and each time for a 3-year term between the ages of 67 and 71, a judge of a national Supreme Court, such as Supreme Court, to continue to carry out his or her duties, such as to give rise to reasonable doubts inter alia in the minds of individuals as to the imperviousness of the judges concerned to external factors and as to their neutrality with respect to any interests before them. I mean, the issue is not, in fact, the issue is not that the prolongation as such, that the president prolongs, but the issue is that it is at the request of the National Council for Judiciary. And it used to be, I mean, majority of the members of the National Council, they used to be elected by their peers, and now it is not the case. They are elected by the legislative branch, and it is an issue that is here at stake. Another case that Stephanie referred to, it is European Commission versus Republic of Poland, and it is a very similar case, but it concerns ordinary judges and prosecutors. After a complaint from the Commission, the European Court of Justice declared provisions of 2017, this new law, regarding the retirement age of judges of common courts and prosecutors incompatible with the European Union law. The retirement age was reduced from 67 to 60 for women and from 67 to 60 for women and to 65 for men. I mean, here was another issue because it was Article 2, it was Article 19, but as well Equal Treatment Directive, because women, it was 60, it was set at 60, and for men it was 65, and it is not, and it shouldn't be so. And here, Article 47 of the Charter could be applied. Because we had the substantive law, secondary substantive law, it was a breach of the substantive law. And it was not an issue whether apply it or not. Before the Court of Justice issued a judgment, the controversial provisions were changed. The Court of Justice of the European Union also underlined that the principles authorizing the Minister of Justice to extend the term of office of a judge after reaching the appropriate age may raise doubts as to the independence of a judge from external factors. A legislative amendment had already been adopted by the Polish authorities to remove the differences in mandatory retirement age of male and female judges and change the regime of prolongation of the active service of ordinary court judges. It is now decided by the National Council for the Judiciary. Yeah, it is, I mean, very similar or parallel issues. The curtailment of the retirement age, as it was with the Supreme Court judges, and then the prolongation. In the case of Supreme Court judges, prolongation by the President of the Republic, and here the prolongation was to be by the Minister of Justice, and it was changed, and it is not by the Minister of it is decided not by the Minister of Justice, but by National Council for Judiciary. This change was made. As far as
I did not understand the reason behind the age limitation for retirement concerning male and female judges. Why is there a difference for retirement ages?
As far as women and because I haven't heard many, can you repeat?
Should I repeat?
Yes.
I wanted to ask what's the difference between male and female judges and their retirement ages? Why is there a difference between their retirement age?
I mean, it is okay. The reasoning was that it is for the well-being of women because they work harder, because they are occupied at home with that they cannot proceed with the career as men.
That's the official reason.
It was, but in our system, it is so that women can retire earlier and men later. I can retire being 65 as man. I have this right, but I have privilege to retire when being 60. But it is the same here. It was changed because it is not mandatory for women to retire when being 60. They can retire as men when being 65. But they have this privilege, they have this privilege of retire earlier when they are 60. And it was always in our system because of, I don't know, positive treatment of women. But it is so. Okay, but it can be positive, but it can be negative because if a woman is 60 and is fired, then it is very difficult for her to find a work because he can be retired. Yes, she does not have to be active because she reached age. She's privileged and she can be retired, and it's not so easy for her being over 60 to find a work.
So in the end, is it mandatory?
No, it is not mandatory. No, it is not mandatory. A woman can retire as a man being 65, when being 65, but her privilege is she can retire when being 60. It is a privilege for being a woman, for women. Women.
And they'd be forced to retire at 60.
No, one cannot be forced. No. It is a privilege. It is a privilege, and now the age is 65, and it is the same it is in Supreme Court. In Supreme Court, it is as well 65. Now, after the change, it is for men, and for women, it is 65, and with ordinary courts, it is as well 65. But for women, it was always privilege. It was always privilege that we can retire earlier. The Commission contested the Polish law, amending the law on the system of ordinary courts and certain other laws of July 2017. Two main aspects were sources of concern. Firstly, the introduction of a difference in retirement ages between men and women, 65 and 60, for judges of Polish courts and public prosecutors. Secondly, the granting of the ministers of justice of the power to extend, at his or her discretion, the period of activity of judges who reached the retirement age, according to the Commission. The Commission claimed, accordingly, the Commission claimed that the court should declare that by instituting under Article 13 of the amending law a different retirement age for men and women, for judges of ordinary courts, the Supreme Court, and public prosecutors, Poland has failed to fulfill the obligations under Article 157. It is non-discrimination and the Equal Treatment Directive, and declare that by lowering under Article 13 of the aforementioned law the age of retirement of judges of the ordinary courts, and investing the Minister for Justice with the discretion to extend the active period of such judges, it is whether retirement or not, yes, the active period of such judges, of such judges under Article 1 of the same law. Poland has breached its obligations under Article 19, second paragraph, and Article 47 of the Charter. And then here there's this difference, yes. There's this difference because we have Article 19, yes, as well, values in Article rule of law, values in Article from Article 2, and we have Article 47 because we have here a substantive law that was breached. Article 157, this material, the substantive law that is required under Article 258, and it is as well required under preliminary ruling. It must be the case, and some cases after preliminary ruling they were inadmissible because there was not substance behind them. And here we have this directive, Equal Treatment Directive. As far as the Advocate General reasoning goes, it was similar reasoning as in the case concerning the Supreme Court. And the court, as for the court, as regards the first plea, the Commission claimed the breach of the principle of equal treatment of men and women in employment as enshrined in Article 157 and Equal Treatment Directive. The court sided with the Commission. Firstly, it declared that the pension paid scheme fulfilled the notion of pay under Article 157. It is the point, it is the issue. I mean, it was the pension, whether the pension is a pay. I mean, my pension is a pay, but in case, what I mentioned, in case of judges and prosecutors, it is. I mean, after having reached the age, whether they retire or not, because. I mean, in my language, Polish language, it is stan spoczynku. It is not retirement as such. That's okay. They are retired. Okay, but this is not a retirement as for other citizens. Yes, that is the case. Firstly, it declared that the pension paid scheme fulfilled the notion of pay under Article 157 and the directive, and then it found the difference in retirement ages to be directly discriminatory and thus in violation of Article 57 and the directive. Such a discrimination could not be justified on the basis of the Polish argument that the measure was aimed at removing discriminations against women. Because for us it is more difficult, because at the same time we do not have one work, but we have, I don't know, 2 or 3 home children, and sometimes because career is interrupted as well, very often because of leave period. And second, the Commission claimed that the combination of the lowering of retirement age and the new powers granted to the Minister of Justice undermines the principle of effective legal protection as stated in the second paragraph of Article 19 in conjunction with Article 47. Now, it could be applied. After having recalled the scope of application of Article 19, as interpreted in Association Syndicale and the notion of judicial independence, the court upheld the Commission's plea. And here once more, the court found that since Poland, it is may, but found that might be called to rule on questions related to the European Union law, prospective in future, potential, might in the future, Article 19 applies to them. It is not in dispute that the ordinary Polish courts may in the capacity be called upon to rule on questions relating to the application and interpretation of European Union law, and that as courts or tribunals within the meaning of European Union law, they come within the Polish judicial system in the fields covered by European Union law, within the meaning of the second subparagraph of Article 19, so that those courts must meet the requirements of effective judicial protection. Okay, it is understandable because national courts, national judges are at the same time European courts, European judges, and it is understandable in order, the system to work, it must be so. Everyone has to comply with, has to steer to the rules. Then here we see this, especially with this in this paragraph, this judicial activism from Luxembourg. And as for the powers vested in the Minister of Justice to extend the term of office of judges, it is true that that the fact that an organ such as Minister of Justice is entrusted with the power to decide whether or not to grant any extension to the period of judicial activity beyond normal retirement age is not sufficient in itself to conclude that the principle of judicial independence has been undermined. As such, the issue that the Minister of Justice decides, it is not an issue, but many elements which are combined together, they raise reasonable doubt as far as rule of law is concerned. However, it is necessary to ensure that the substantive conditions and detailed procedural rules governing the adoption of such decisions are such that they cannot give rise to reasonable doubts in the minds of individuals as to the impartialness of the judges, concerned the external factors, and as to their neutrality with respect to the interests before them. And then we have another two cases, but these cases are pending in the European Court of Justice. But they concern disciplinary regime, and it was law of the 8th December 2017 on the Supreme Court, which entered into force in April 2018. And this law has raised concerns that it lacks appropriate safeguards to protect judicial independence due to the risk that judges may be sanctioned because of the content of judicial decisions, including decisions to request preliminary rulings from the Court of Justice of the European Union. Moreover, concerns remain with regard to the independence of the disciplinary chamber, which acts as the final instance for disciplinary cases and is composed solely of judges selected by the newly composed National Council for Judiciary. The Commission decided, it was in October 2019, to refer Poland to the Court of Justice, contesting these new arrangements. In April 2019, the Commission launched the infringement procedure on the grounds that the new disciplinary regime undermined the judicial independence of Polish judges and did not ensure the necessary guarantee to protect judges from political control as required by the court. It was in April 2020, following a request for interim measures, the court ordered Poland to immediately suspend the application of the national provision and the powers of the disciplinary chamber with regard to the disciplinary cases concerning judges. I have. And then there is another case. It concerns as well disciplinary offenses, disciplinary cases. And it is because of the law which was introduced in December 2019, but it entered into force. It was at the very beginning of 2020, and the law of December 2019 further broadened the notion of disciplinary offense and increased the risk to judicial independence. This issue is an element of the new infringement proceedings launched by the Commission in April 2020 and referred to the court in March 2021. The Commission referred an action to the court and applied for a declaration that the Polish so-called, and it is muzzle law. I mean, I think everyone heard about it, and it is very, very famous now. I mean, muzzle law infringed Poland's obligations under European Union law. According to the Commission, the Polish law on the judiciary of December 2019, in fact 2020, that entered into force, as I said, February 2020, undermines the independence of Polish judges and is incompatible with the primacy of EU law. The Commission set out 5 reasons why Polish so-called muzzle law violated provisions of EU law protecting judicial independence. One particularly crucial point is that the law prevented Polish courts from submitting references for preliminary rulings on questions of independence of independence to the Court of Justice of the European Union. It was an issue, yes. It was not. It was more that judges, they were afraid of the consequences. It was not that because they know that they can submit such questions under European law. They can do it. We have this judicial cooperation, and each and every judge knows it. But they feared because of consequences that can be. This included threats to Polish judges about the use of disciplinary proceedings against them. The Commission has also asked the court to order interim measures pending the delivery of the final judgment. And the law, I mean this famous muzzle law, granted the new Chamber of Extraordinary Control and Public Affairs the sole power to decide on issues related to judicial independence. The new disciplinary chamber has been given the competence to lift the immunity of judges when criminal proceedings are brought against them, introduced a general prohibition for Polish courts to challenge the powers of courts and tribunals, constitutional organs, and law enforcement agencies, prevents Polish judges from ruling on the lawfulness of judicial appointments and on judges' power to perform judicial functions. The same prohibition applies to judges assessing the lawfulness of the composition of a hearing bench, and introduce new limits on statements and actions that can be made by judges, courts, and other independent bodies. And now, then here we had four cases. 2 cases that were decided by the Court of Justice and 2 cases that are still pending in the Court of Justice. The cases which were decided concerned Supreme Court judges and curtailment of pensions and the prolongation of their mandate. The same was when I spoke about the ordinary judges, and the second case, ordinary judges and prosecutors, curtailment of their mandate, and then or active service, and then the prolongation by the Minister of Justice. And 2 cases that are pending, they concern the disciplinary offences. And now we have Article 267, preliminary ruling procedures, and some cases went to the Court of Justice of the European Union via this instrument, via Article 267. On November 19th, 2019, upon the preliminary references of the Supreme Court on the independence and impartiality of the newly created disciplinary chamber, the court considered that for the participation of the Council for the Judiciary in making the appointment process of judges by the President of the Republic more objective, such body must itself be sufficiently independent of the legislature and executive and of the body to which it gives an opinion. The court stated that the referring court, in this case it is Supreme Court, will need to assess, it is for the referring court to assess in the light where relevant of the reasons and specific objectives alleged before it in order to satisfy certain of the measures in question, whether taken together, it is important, whether taken together, because these measures, I mean, these new arrangements as such individually, they are not of such a concern. Okay, they do concern, but not as such. But these measures taken together, it is an issue. It is a concern. Taken together, the factors referred to in paragraph 104, yeah, but it is 143 and 151. Of the case decided by the court, and all other relevant findings of fact which it will have made are capable of giving rise to legitimate doubts in the minds of subjects, individuals of the law, as the imperviousness of the disciplinary chamber to external factors, and in particular to the direct or indirect influence of the legislature and the executive, and as to its neutrality with respect to the interest before it, and thus whether they may lead to the chamber not being seen to be independent or impartial, with the consequence of prejudicing the trust which justice in a democratic society must inspire in subjects of the law. I'm sorry, but it is the extract from what Court of Justice said, but. What I wanted to say, these cases which were brought to the European Court of Justice, they have consequences in the internal context. On January the 23rd, in 2020, the Supreme Court, referring to the Court of Justice of the European Union's ruling of December the 19th, 2019, issued a resolution stating that the newly composed National Council for the Judiciary is not independent, and asserting that new Supreme Court judges selected by it are not allowed to adjudicate cases. It means that there was a referral, there was a question from the Supreme Court to the Court of Justice of the European Union, and then there was an answer from the European Court of Justice, and via this resolution, Supreme Court implemented. It was not direct implementation, but implemented the interpretation given by the Court of Justice of the European Union. But this resolution of the Supreme Court was subsequently found to be inconsistent with the Constitution and with the European Union law by the Constitutional Tribunal, adjudicating upon request of the Prime Minister, of the Marshal of the same, and supported by the President of the Republic and by the Prosecutor General. The Supreme Court, however, has continued to apply the resolution of January the 23rd, it is on the part of the Supreme Court, but in turn, the National Council for Judiciary continues to propose candidates for judicial appointments to the President of the Republic. It means that one thing, the Supreme Court sticks to its interpretation, to its resolution, but the National Council sticks to its law. The two new chambers of the Supreme Court, created under the 2018 reform, have been granted new powers in 2019. The Disciplinary Chamber and the Chamber of Extraordinary Control and Public Affairs are composed solely of new judges appointed at the request of the newly composed National Council for Judiciary. And following the Court of Justice of the European Union's ruling, which I mentioned, in November 2019, the Supreme Court, in 3 rulings, found that disciplinary chamber not to be an independent court within the meaning of European Union and national law. It means that the Court of Justice of the European Union, after having received the interpretation from the Court of Justice of the European Union, issued a resolution and then issued 3 judgments. Saying that were found that disciplinary chamber is not an independent court within the meaning of EU and national law, neither within the meaning of European law and national law, but the disciplinary chamber of the Supreme Court qualified the judgment as a serious threat to the stability of the legal order. It considered that the Court of Justice of the European Union's judgment of November 1920 cannot be considered as binding in the Polish legal system. An allegation of incompatibility with the scope of the powers conferred on the European Union by the state and hence ultra vires. It means that the disciplinary chamber ruled that judgments of the Court of Justice of the European Union is ultra vires because it is behind the competences that were conferred to the European Union by Polish authorities, by Poland. And there are also two judgments of the Constitutional Tribunal concerning the implementation of the Court of Justice of the European Union's judgment of November 19 in the way of Supreme Court's resolution. In the judgment of April 2020, the Constitutional Tribunal contested the understanding of the principles of the rule of law, democracy, and sincere cooperation adopted by the Court of Justice of the European Union. In turn, in its decision of April 2020, the Constitutional Tribunal stated the ultra vires nature of the Court of Justice of the European Union judgment regarding the independence and impartiality of courts in Poland, and condemned the Supreme Court for referring questions for a preliminary ruling to the Court of Justice of the European Union regarding the allegedly Polish system of justice. It means that that there are repercussions, in the internal Polish judicial systems. It means that it is not only that it is not that case ended. The case ended in the European Court of Justice, but still it is in our system, and it is Constitutional Court, Disciplinary Chamber, Supreme Court that take stance on the issue. And then we have the judgment of the judgment of the court, but. Judgment of the Court of March 2020, but in fact, in this case, the Court said that the case is inadmissible. It was a case of three courts, joint cases, concerning the interpretation of Article 19, creating an obligation on the part of the member states to establish remedies necessary to ensure effective judicial protection in the areas covered by European Union law. It is a repetition of Article 19.1 in the context of disciplinary proceedings against judges in Poland. In the context against judges in Poland, the disciplinary chamber of the Supreme Court, consisting of judges selected by the politically subordinated National Council of Judiciary in a legally invalid competition. These cases were about the independence of judges and courts, wherein there was no European link in the form of substantive law. However, for a court to be considered functionally European, it is sufficient, in accordance with the judgment in the case Association Syndicale, to prove that the jurisdiction covers cases with European link, areas covered by European Union law within the meaning of Article 19, and thus most national courts are at the same time functionally European courts. But in the case of a request for a preliminary ruling, it is important to demonstrate that restrictions on the independence of courts and judges translate into specific case, which is subject of the question and thus may affect the decision, and it was not here the case. The referring courts were of the opinion that the model of disciplinary proceedings in Poland infringes the requirement of effective judicial protection under Article 19. It gives the politician, cum Minister of Justice and cum Prosecutor General, almost unlimited power in the field of disciplinary proceedings against judges. He becomes the one who initiates the proceedings and influences the composition of the disciplinary court, which, given the limited procedural guarantees for the accused, brings disciplinary proceedings against judges closer to the model of inquisitional proceedings. We have these two kinds of proceedings, and inquisitional proceedings we know from the history, and it is not a positive picture. The definition of offences for which the national judge is responsible is also imprecise, what Stephanie referred to, which additionally increased the scope of the discretionary power of the Minister of Justice. The adopted model of disciplinary proceedings makes the disciplinary judiciary a tool for removing persons issuing sentences that are not to the liking of the executive. The reference for a preliminary ruling by Polish courts goes beyond the traditional way of presenting them. They reveal the phenomena so far absent in the court jurisprudence, a systemic problem with the independence of courts and judges. It is not an individual, it is systemic problems with the independence of courts and judges. In one of the member states, the systemic problem extends to areas covered by European Union law and translates into the settlement of specific court cases. But the court found that the request being inadmissible, being a hypothetical issue, hypothetical question, because it was not an issue as such. It was on a scheme, a model of this disciplinary procedure that was at stake. And another one Because there are so many cases. There are so many cases.
Crazy, I mean,
Yes, it's crazy.
You need, you need a European project just to map out all these cases.
Yeah.
The database, like the
Database. Yeah, but it is not only a problem of Poland, Hungary, and as you said, Cyprus, Article 19, and many other countries. Then and the rule of law, it did not start. In fact, it started France in 2010 with Roma and France, and it did. Okay, in Poland it is 2015. Okay, it is a system was different, and system was changed, but I mean, what is the issue? When we look at the curtailment of active service, I mean, the issue are people that used to work before 1989. I mean, it is my explanation. I see it. It does not have to be, but yeah. But there is another issue. Another issue is that, and it is not exposed so much, but there is a law in Poland that allows reopening of old cases. The cases that were closed, they can be reopened now, and who decides? Who decided? And what the case is about? But yeah, that is another issue here, and I don't know which one is more important. Which one covered which one?
Is this law a recent law or is it an old law?
No, this opening cases, a recent law.
A recent law?
Yes, it is recent law. It is a recent law. I will tell about tomorrow. I will just mention it tomorrow that it is an issue, and here speaking to some people, I mean the voices. I hear the voices. The issue is not individual judges. It is not the judiciary system. The issue may be somewhere else. Then it is okay, but there are so many questions.
Danuta,
Yeah.
because I see the time.
Yeah.
And people have been patiently listening
Yes.
all morning long. They probably have questions.
Okay.
So how much more do you have?
Okay, then I will just there's another case, but it was and it was as well inadmissible interim measures, but I told about it. There is one more slide, and that's all I may finish. Okay.
You can take 15 or 20 minutes.
Yeah, 10 minutes, and that's no more. As far as yes, other issues surrounding the independence of judiciary. I mean, the issue is that that Polish citizens that committed crime somewhere abroad, they can now say that they are afraid of Polish judges being under external influence, and they do not want to. To be sent back to Poland under European arrest warrant, and there are two cases that I wanted to show you. The question of the Irish High Court was submitted to the Court of Justice of the European Union. It was March 27th, 2018, and was considered under an urgent procedure in which the Irish court, in the context of the execution of the European arrest warrant coming from Poland, asked about the necessity to execute an European arrest warrant in the situation of convincing evidence that the conditions in the issuing European arrest warrant member state violated the fundamental rights to a fair trial, as justice was no longer based on the rule of law and there has been a major systemic breach of the principle. The court found that domestic courts would be obliged automatically refuse to execute a European arrest warrant in the event of sanctions imposed under Article 7.2. And it is an issue. If it had been decided under Article 7, but not 7.1, But 7.2 by the European Council, by the European Council, in the there is unanimity by the European Council that there is a systemic breach of the rule of law in Poland, then under European arrest warrant, the refusal to execute this European arrest warrant would be automatic. It means that there would be not a judge that has doubts does not have to go to the Court of Justice of the European Union, or does not have to assess whether the domestic judicial system is independent or is not independent, and it is a very, very important issue. The court found that domestic courts would be obliged to automatically refuse to execute a European arrest warrant in the event of sanctions under Article 7.2. The court also indicated that the courts of the member states might also, in case of doubts, review the state of compliance with the rule of law in a member state. This led to the conclusion that national courts in the other member states might undermine the principle of mutual trust in relation to not have a binding, to not law-abiding states. It means that that now, when it is decided under Article 7.1, but now it is not decided, it is still European Council deliberates. I'm sorry, not the European Council, but Council of the European Union deliberates. But if it is decided under Article 7.1, then it is still the work of the judge, of the Irish judge, to assess compliance, the compliance of domestic judiciary with the rule of law. It is still the work for the in this case Irish judge to assess the case and then decide whether to execute the European arrest warrant or not. And but under Article 7.2, it would be not the case. It is an automatic refusal. And therefore, it is, according to the court, therefore it is only in the European Council where to adopt a decision determining, as provided for in Article 7.2, that there is a serious and persistent breach in the issuing member state of the principles set out in Article 2, such as those inherent in the rule of law, and the Council were then to suspend framework decision in respect of that member state, that the executing judicial authority would be required to refuse automatically to execute any European arrest warrant issued by it without having to carry out any specific assessment of whether the individuals concerned runs a real risk that the essence of the fundamental right to a fair trial will be affected. And if it is under 7.2, then it is automatic refusal. And now, if it is under 7.1, then the judge must assess whether there is a risk as far as the domestic judiciary is concerned. Concerning the risk to fair trial, it is an issue. The principle of fair trial. It is one case, and another one. It was July 2020. The Court of Amsterdam made a request for a preliminary ruling in the context of an execution of a European arrest warrant, the same, issued against a Polish citizen, seeking clarifications regarding its obligation under EU law in the light of the recent changes in the Polish justice system. And the answer given by the Court of Justice was very similar. Article 6 and 1 of the Council framework on the European arrest warrant and the surrender procedures between member states, as amended by the Council decision, must be interpreted as meaning that where the executing judicial authority, which is called upon to decide whether a person in respect of whom a European arrest warrant has been issued is to be surrendered, has evidence of systemic or generalized deficiencies concerning the independence of the judiciary in the member state authority, cannot deny the status of issuing judicial authority to the court which issued that arrest warrant, and cannot presume that there are substantial grounds for believing that that person will, if he or she is surrendered to that member state, run a real risk of breach of his or her fundamental rights to a fair trial guaranteed by the second paragraph or Article 47 of the Charter of Fundamental Rights. without carrying out a specific and precise verification which takes account of inter alia his or her personal situation, the nature of the offence in question, and the factual context in which that warrant was issued. Such a statement by public authorities which are liable to interfere with how an individual case is handled. Sorry for such a long statement, but it is an extract from this what states in the case, and it is the same. It is the same because it is not an automatic refusal. It is not because it's not decided by the European Council under Article or pursuant to Article 7.2, and that's why it is up to the court, up to the judge who is deliberating whether to execute or not European arrest warrant, to assess the compliance with the rule of law of the judiciary of the country that requested that sent this European arrest warrant and requested the person to be sent back to the country under either because it can be the issue is it can because of the procedure that will be because of criminal procedure that will be carried out in the domestic country, or just I mean the time that he or she will have to spend in jail. Yeah, that is an issue. It means that rule of law is an important issue because it has repercussions, and it is not only for us, for the citizens, but it has Europe-wide consequences, Europe-wide repercussions, and causes problems and causes difficulties. And as I said, individual issues. It is not a case. It is an issue, but not as hard as taken together. Taken together, it is an issue, and as it was said, the organization of judiciary, it is national competence, and European Union does not have to interfere. But there are limits because national courts are as well European courts, and yes, and we have to think. European law. It is European law. It is not international law. It is national law, and we are obliged, and we have to comply with European law as we do comply with national law. And I don't know. Maybe there is misunderstanding. I would like the best for my country, and I would okay. I love my country, and I would like that everything goes well, and that we stay in the European Union, and that we are an important partner. In the European Union. But the cases are as they are, and it is not. There are many Polish cases, but it is not only Polish problem. The problem, I think, it increases in the European Union. Look, it was ultra vires. German Constitutional Court in May 2020 said that the judgment of the European Court of Justice is ultra vires. But what is now the European Commission is taking Constitutional Court, Bundesverfassungsgericht, to the Court of Justice because of this judgment. Then it is not only the case of my country, but okay, it is as it is. We have to know it, and maybe try to change it for the positive. Okay, thank you very much. Thank you very much, and see you tomorrow because there is. Yeah.
Yes, just wait and we'll see if there are any questions.
Okay.
On share the screen and
Stop.
let's see if anyone has questions.
Okay. Hi, everyone. Thank Danuta very, very much for her presentation. I think it's a very, very interesting topic. And I'm sure that all of you have thought about these questions before, and has done a terrific job of bringing our attention to all the different Polish cases that are in front of the Court of Justice, even though, as she mentioned, they don't represent a specifically Polish problem, but rather a European problem, a Europe-wide problem. So at this stage, if anyone has any questions, you can simply raise your hand and you'll be allowed to ask your questions. If anyone in the room has any questions or any comments, those are also welcome. We still have a few minutes before we head on to our break. So if anyone has any questions, feel free to ask them. Or type in the chat, exactly. If you have anything you'd like to ask.
Just maybe everyone left because of and to have a picture. It is the same with students. Now we have lectures and we see pictures and
yes,
and not
true.
faces and we don't know it. But this is during normal lectures, that's
it's always the case.
Okay, maybe it was too much and it was some new and maybe
well,
maybe they had to digest.
I have something that I'd like to kind of ask or comment. One thing that I found extremely interesting is how you mentioned in a quote of your lecture from the tribunal, a judgment from the tribunal from 2020, saying that our interpretation of the rule of law and democracy are different from the interpretation of the European Union. Yes, that was part of a judgment. And I found interesting two things. First, how closely this rhetoric mirrors the rhetoric of the ruling party in Poland, because Kaczynski said something very, very similar to that. And secondly, I was wondering if you think that part of the solution to the rule of law problem might be a European-wide instrument where the rule of law and conditions of the rule of law and requirements of the rule of law, such as those described by about judicial independence that Stefan mentioned earlier, or some of the requirements that you mentioned here, could be kind of collected centrally.
Yeah, but now,
notwithstanding all the practical problems and the political problems that would require.
But I think after this judgment in 2018, we have this instrument. We didn't have it, but now we have. We have this 267 and 258. We can make Article 19 as an independent legal basis. We don't have this instrument.
Yes,
it's still weak, but
I think the problem is that you rarely point out to Article 19, right? But Article 19 talks about effective protections of the judiciary.
Yes.
But that's only part of the rule of law.
Yeah, that's true. Yeah.
Right. So if we're looking at overwhelming protections of the rule of law, overall protections of the rule of law, then Article 19, yeah, it's kind of a starting point, kind of the very basic, the very minimum of the rule of law that we might understand. But there are other aspects of the rule of law. Some of them came up during your presentation, right, with other cases.
Yes, that's true. This means that maybe we need just systemic instrument.
Yes.
Okay, we have intergovernmental conference started. We are EU citizens. We have the right to send our requests. There is a platform. It is as well our responsibility, our work. But I think they are institutions are aware of it. Intergovernmental conferences, it's conference intergovernmental between the member states. They will want to agree on something like this note. Okay, they agreed on Article 7 because they thought it is only political. They didn't think that it would be possible as well under Article 258 and Article 267 because it wasn't, but now it seems that it is possible. It seems in practical terms. It would be very, I think, yeah, because, who is, member states are masters of the treaties. And I think having the experience, I think member states will not agree. I doubt my country.
Yeah, no, I mean, I do agree with that assessment.
I know that Prime Minister, he knows European law because I studied with him. We met in Germany. We studied European law in Germany, in Hamburg. Then yeah, but he should know what he's talking about. But
see, I don't think it's a problem of ignorance. I don't think it's a problem of them not knowing European Union law. It's just a matter of taking deliberately a different path.
Yes, a different stance. Okay, with law and peace. Yeah, it is law and justice, not law and justice. Private public law and justice. They stick to this. I think what I said at the very beginning, to this very classical interpretation of international law. The competences that we conferred. These are only these competences, and we do not agree on the interpretation of the European Court of Justice because there is a tendency in the European Court of Justice to broaden and how many implied powers, parallel powers. It is this judicial activism, and it is this tendency. I started as well with Professor Lenartz, that and he is now the president of the Court of Justice. The Law and Justice Party takes the European law interprets the European law as international law. In my view, as classic, or wants to see it as classical international law. That these are the competences you conferred, and this is from A to B, and nothing more. But do not take. Yes, but in the judicial region, the Judicial Court of Justice interprets according to the FAQ. It is not literal interpretation. Yeah. And the people, and there are people who know what does it mean: the systematic interpretation, the literal interpretation, and FAQ. If you have FAQ, you can interpret it very broadly, and it is the stance of the European Court of Justice from the very beginning. That is why I said I know that people know, because they are very educated people, they do know that, but they interpret it in compliance with the national interest, I would say. Okay, the national interest is very important, but the national interest must be in line with as well with the European interest.
Then within the context.
Yes, within the context, and it is a difficult issue because I know people. Being in this environment, as well from law and justice and from constitutional court, that these are highly political issues, and I am not the
of course.
I'm only academic that can interpret objectively, what is at stake. I would prefer the cases not to be in the court, because the point is that it is not the European Court of Justice. There are repercussions. Then we have the conflict, Prime Minister, public prosecutor, with the Constitutional Court, with the Supreme Court. We have now there is a case from the Prime Minister to the Constitutional Court concerning the European law, that the judgments of the Court of Justice, the Court of Justice goes behind its competences, and it is a request from the Prime Minister, which I started, European law, from the Prime Minister to the Constitutional Court to declare the European law of ultra-vires. But it is not national courts, Constitutional Court, Supreme Court. They can decide on national law. They cannot decide on European law. It is only European Court of Justice that can say that something is ultra-vires, and it is the same in Bundesverfassungsgericht. It is not for Bundesverfassungsgericht to say that European law is ultra-vires. It is because Bundesverfassungsgericht decides on German cases, on German law, and not on European law. But there is this conflict, this competition or dialogue between constitutional courts, and there is another issue I will touch tomorrow. This national and European identity. Yeah. This core competences that they are immune from the European judges, from the judges from Luxembourg. And then, if these are the core competences, and the rule of law is, as far as Poland is concerned, falls under this core competence, and that's why it is an issue. Even because it is an agreement between the European Court of Justice and national courts. If something falls under core competences, it is immune from the European Court of Justice. And the rule of law in Polish context, in Polish constitution, it is a part of this constitutional core. That's another problem. It means that each side has its own discussion history, its own arguments, and presents its arguments. But we are all in the European Union, and if you want this system to work, and we do want, and I'm happy to be here because of the European Union. For us, maybe I would wish there is another issue apart from the rule of law. The reduction or curtailment of our free movement rights. I know that because of COVID and other issues, but if it states says it is not good for us as European citizens. Now it is understandable, but for us, but as a temporary measure, but not.
Yeah,
as
of course.
permanent.
This is a very,
Yeah.
a very big issue in and of itself.
But you know, we will see what will be after conference, because the studio conference, it is for us just to write our wishes, but we will see what will be the new treaty. But because member states are having their Verträge, it means master of the treaties. It is up to them, and they on very big changes.
Yeah, not very optimistic there. Do you have any other questions or anything anyone else would like to comment or ask? No?
There's nothing online either.
Okay. Then
Okay.
I think, okay.
Well, then, thank you very much, Danuta,
Thank you, Danuta.
for this lovely presentation. Thanks everyone for being here. We are going to take a break.